is the way forward. Thereafter, the keynote address will be delivered by, by Honorable Shri Arjun Ram Meghwal sir, Honorable Union Minister of Law and Justice, followed by the valedictory session by Honorable Justice Manmohan, Judge, Supreme Court of India. We will conclude with closing remarks and a vote of thanks by Mr. Divyansh Anurati, Honorary Secretary, Indian Dispute Resolution Center, and Managing Partner at Lexidum and Rathi. Now, I would like to introduce Mr. Ved Prakash Sharma sir, Co-Chairman, Bar Council of India. Ved sir started his practice in 1978 as a trial court lawyer and made a significant mark in this field of law practice. He was elected President of Delhi Bar Association thrice in 2001-2, 2002-3, and 2006-8. Sir has been a member of Bar Council of Delhi continuously since 2003 and was its chairman in 2009 and 10. Sir was elected to the Bar Council of India in 2018 and became its co-chairman in 2019. Ved sir is also a member of the Executive Council of the National Law School of India, Bangalore and NLU Delhi, and takes a keen interest in ensuring that the standard of Indian legal education continues to gain noticeable excellence and stays in competition with the world-class legal educational institutions. It is our pleasure to be collaborating with IIULER and Bar Council of India for the Arbitration in India Conclave. And I thank Manan Kumar Mishra sir and Ved Prakash Sharma sir for their continued support and guidance to us. May I now please request Ved Prakash Sharma sir to please join us on the stage and deliver the inaugural address. And I would like to request Mr. Sanjay Rathi sir to kindly felicitate sir before the inaugural address.
Namaskar. Good evening to all the distinguished guests, respected colleagues, learned panelists, delegates and participants. It truly fills me with joy and pride to stand before this esteemed gathering at the 4th Arbitration in India Conclave, hosted by the Indian Dispute Resolution Center in collaboration with the Bar Council of India and the India International University of Legal Education and Research. Let me begin by extending a very warm welcome to each one of you. Your presence here in such a large number is not just encouraging, but also deeply meaningful. It reflects the growing recognition and importance of arbitration in today's rapidly evolving legal landscape. At the very outset, I want to take a moment to express my heartfelt appreciation to the IDRC team for their continued dedication and tireless efforts in organizing this conclave. Over the years, RDRC has become more than just an institution. It has become a platform that promotes dialogue, learning and collaboration in the field of dispute resolution. Its contribution to strengthening India's arbitration ecosystem has been remarkable, and I have no doubt that this year's conclave will carry that legal legacy forward with even greater energy and impact. I am equally delighted to acknowledge the presence of eminent personalities from the judiciary, the bar, academia, and the business community. Each of you plays an essential role in shaping and sustaining the arbitration framework in India. Your participation here today reflects our shared mission to position our country as a global leader in the field of dispute resolution. Now, as we reflect on collaboration, I am pleased to highlight that this conclave also marks the third year of partnership between the Bar Council of India and the Indian Dispute Resolution Center. This partnership has been a deeply productive and rewarding collaboration. Together, we have worked with commitment and vision to create greater awareness about arbitration and to support legal reforms that will help India emerge as a true hub for institutional arbitration. The Bar Council of India has always been at the forefront of efforts to improve the quality of legal education, enhance professional standards, and strengthen the practice of law across the country. Through this partnership with IDRC, we have ensured that the highest standards are maintained in arbitration proceedings. Together, we have created a strong platform for the exchange of knowledge, experience, and insights among arbitration professionals, legal practitioners, and academic institutions. This synergy between the BCI's work with legal professionals and the IDRC's focus on practical dispute resolution is powerful. It's a combination that promises to bring about real and lasting change. As we look to the future, we are determined to continue this partnership with the same spirit of collaboration and purpose. The Bar Council of India remains fully committed to ensuring that our legal system supports an efficient and transparent arbitration process and that our legal professionals are equipped with the knowledge and skills to excel in this evolving field. It's a privilege to share a few thoughts on today's very relevant and forward-looking topic, autonomy and accountability in arbitration. Institutional arbitration is the way forward. This topic lies at the heart of India's ongoing transformation into a global hub for dispute resolution. It captures two essential pillars of modern arbitration: the freedom of the parties and the fairness of the process, both of which must coexist for arbitration to truly serve justice. When we speak of autonomy in arbitration, we refer to the freedom of the parties enjoy to shape their own dispute resolution process. This includes the right to choose their arbitrator, the place of arbitration, the governing law, and even the procedural rules that will apply. It is this flexibility that makes arbitration attractive. It allows parties to avoid rigid courtroom procedures and find solutions tailored to their commercial realities. But autonomy cannot exist in a vacuum. This is where accountability plays a crucial role. Accountability ensures that every arbitrator acts with integrity, independence, and transparency. It safeguards the fairness of the process so that neither party feels disadvantaged. Without accountability, autonomy can easily slip into dominance, where one party gains undue influence over the proceedings. The real strength of arbitration lies in striking this delicate balance, where freedom meets fairness and efficiency walks hand in hand with integrity. And the most effective way to achieve this balance is through institutional arbitration. Under institutional systems, recognized arbitration bodies oversee the proceedings, provide structured guidance, and ensure neutrality in the appointment of arbitrators. Institutional arbitration brings with it built-in checks and balances. It ensures procedural discipline, ethical conduct, and administrative support elements that are often missing in ad hoc arbitration. In that sense, institutional arbitration is not just a better option, it is the natural way forward. It creates an ecosystem where autonomy and accountability coexist, where efficiency does not compromise fairness, and where India can confidently position itself as a credible global hub for dispute resolution. In recent years, however, several questions have been raised about the efficacy of arbitration as a truly credible and efficient alternative to conventional court litigation. Concerns regarding the rising cost of proceedings, procedural delays, and the layered mechanism of objections and appeals have led some to describe arbitration as a second tier of litigation. Yet, these concerns do not undermine the value of arbitration. Rather, they invite constructive introspection within the legal community. Perhaps it is time for us to reflect on how the arbitral process can be made more accessible, predictable, and affordable without compromising its autonomy or integrity. Institutions such as IDRC and ILR, working in close cooperation with the Bar Council of India, are ideally positioned to lead this reform-oriented discourse and to strengthen public confidence in arbitration as an effective means of justice delivery. Now, let me turn to a very important development that reflects India's evolving commitment to creating a world-class arbitration framework. The Draft Arbitration and Conciliation Amendment Bill 2024. This proposed legislation is another forward-looking step by the Government of India to align our arbitration system with international best practices. The bill aims to make arbitration more efficient, transparent, and technologically equipped. Three qualities that define modern dispute resolution. The draft bill proposes a range of progressive measures. It seeks to promote institutional arbitration, encouraging parties to approach recognized arbitration centers instead of relying on ad hoc arrangements. It also proposes the introduction of emergency arbitration, which will allow urgent interim relief even before the arbitral tribunal is formally constituted, and reform that reflects the realities of modern commercial disputes. Further, the bill empowers the Arbitration Council of India to frame model rules for arbitral proceedings and lay down a clear framework for institutional arbitration. It even envisages digital integration, allowing arbitral proceedings to be conducted through online platforms, including video conferencing for submissions, hearing, and evidence presentation. Another significant proposal is the creation of an appellate arbitral tribunal, which will hear appeals against orders under Section 34, those that seek to set aside arbitral awards. This addition could make the review process more specialized and efficient. Equally important, the bill addresses long-standing concerns around delays in court-related matters. It introduces strict timelines for court applications, whether it is filing a challenge under Section 37 or making an application under Section 8, ensuring that the entire process becomes more structured and predictable. At its core, this bill represents India's strong intent to strengthen institutional arbitration and to give arbitral institutions the autonomy and authority needed to manage disputes more efficiently and transparently. Now, while the legislature is working to strengthen the system through reforms, the judiciary has also been playing a vital role in shaping the principles that guide arbitration in India. In November 2024, the Supreme Court of India delivered a landmark judgment in the case of Central Organization for Railway Electrification, the five-judge bench considered a crucial question: whether an arbitration clause that allowed one party to prepare a panel of arbitrators from which the other party could choose met the test of fairness and impartiality under the Arbitration and Conciliation Act 1996. The court made several strong and clarifying observations. It emphasized that impartiality and independence formed the very foundation of arbitration. Referring to section 12(5) of the Act, the court reaffirmed that no person with any conflict of interest, whether professional, personal, or institutional, can serve as an arbitrator. The judgment also made an important distinction. While party autonomy is a cornerstone of arbitration, it cannot override the principles of fairness and neutrality. Autonomy cannot become a shield for one-sided control. Section 12(5), the court said, is a non-negotiable safeguard, ensuring that arbitrators remain completely independent of both parties and the dispute itself. The court further observed that unilateral appointments by public sector undertakings, especially where retired officers of the same organization are proposed as arbitrators, create an inherent risk of bias and violate the spirit of equality enshrined in section 18 of the Act. In the case at hand, the clause that permitted the Railway Electrification Organization to select arbitrators from a panel of its own retired officers was struck down as being inconsistent with the requirement of an independent tribunal. However, the court also made its ruling prospective, applying only to arbitrations initiated after the date of the judgment. This decision is more than a ruling. It is a reaffirmation of the core principles that sustain faith in arbitration, equality, independence, and fairness. Together with the 2024 Amendment Bill, it represents India's journey towards creating an arbitration framework that is not only efficient but also deeply just and trustworthy. In addition to our work with IDRC, I would also like to mention the India International University of Legal Education and Research, ILR, in Goa, which is part of the Bar Council of India's broader mission to advance legal education and research. ILR is a forward-thinking institution dedicated to providing world-class education that aligns with global best practices in the field of law. The university focuses on delivering specialized courses in various fields, including arbitration, international trade, and dispute resolution. Through its academic programs, ILR is cultivating a new generation of legal experts who will lead the way in promoting institutional arbitration and resolving disputes effectively. The Bar Council of India, through its partnership with ILR, is committed to ensuring that the highest standards of legal education are imparted to students, with a special emphasis on alternative dispute resolution mechanisms, including arbitration. As we continue to strengthen the infrastructure around arbitration, ILR stands as a pillar in developing a legal workforce that is highly proficient in the complexities of dispute resolution, ensuring that future generation of lawyers are well equipped to meet the evolving demands of arbitration. As I conclude, I would like to reassert the importance of the discussions and dialogues that will take place over the course of this conclave. This is a unique opportunity for all of us, legal professionals, academicians, business leaders, and arbitrators, to come together and collaborate on how we can build a more robust and effective arbitration ecosystem in India. Let us make the most of this occasion to share ideas, forge new connections, and work together to ensure that India not only becomes a leader in institutional arbitration but also remains a beacon for fair, transparent, and efficient dispute resolution worldwide. Thank you very much.
Thank you, Ved sir, for sharing your wisdom and the thoroughly engaging words on the current scenario of arbitration in India, the challenges we are facing, and the roadmap we need to embark on for becoming the international arbitration hub. I'm pleased to introduce you to our esteemed panelists for this evening. I'd like to request Shri S.T. Sanjay sir, Additional Solicitor General, Supreme Court of India, Ms. Anuradha Dutt ma'am, Senior Partner, DMD Advocates, Mr. Ayush Agarwala sir, Partner, Bombay Law Chambers, Ms. Shruti Sabharwal ma'am, Partner, Shardul Amarchand Mangaldas, and Mr. Shashwat Bajpai, Founding Partner at DRSP Law Chambers, to kindly grace the dais. Unfortunately, Justice Tejas Karya could not join us today due to his health issues. With the due, may I please request the panelists on stage, please? With the due permission of our panelists, we commence our conclave. Now I'd like to introduce our esteemed panelist, Mr. S.D. Sanjay sir. We have with us Mr. S.D. Sanjay sir, Additional Solicitor General of India, and a senior advocate with an enriching experience spanning over 4 decades in litigation. He is an Additional Solicitor General of India and is advising and representing the Union of India in significant constitutional and public matters. Sanjay sir has served us as ASG for the Patna High Court and as AAG for the state of Bihar. He is an alumnus of the Campus Law Center, University of Delhi, and is known for his expertise in complex and high-profile legal matters. As ASG in the Supreme Court of India, Sir continues to contribute to the development of jurisprudence with a balanced approach, sharp advocacy, and unwavering commitment to justice. Thank you, sir, for joining us today and being a part of this esteemed panel. We thank you for your time, sir. May I please request Mr. Divyanshu Anurati to kindly come and welcome and felicitate, sir.
Now moving on to our next panelist, we have with us Anuradha Dutt ma'am, Senior Partner, DMD Advocates. Anuradha Dutt ma'am is the founder and managing partner of DMD Advocates and heads the firm's litigation group. She is a seasoned lawyer with over 40 years of experience in representing clients in litigation and arbitration. Her expertise lies in tax, civil and commercial and corporate litigation. She represents Indian and international clients including some Fortune 500 and 1000 companies, large to mid-sized Indian businesses. She has been involved in some of the prominent and landmark cases in India and has been contributor to development of jurisprudence in India through her representation on such matters. Anuradha Dutt ma'am continues to represent clients in matters before Supreme Court of India and High Courts across India and other cities, especially special CBI courts and in ED cases, and also represents clients before various arbitral tribunals, mediation and conciliation forums. She has been involved in arbitrations under renowned arbitration councils including ICC, ICA, PCA at The Hague, LCIA and Singapore Mediation Center. She has extensive experience in international arbitrations relating to bilateral investment treaties, and she has made invaluable contribution to matters related to BITs. She has handled complex matters across multiple jurisdictions. Thank you for joining us today, ma'am, and sparing your valuable time. May I please request Sumedha to please felicitate ma'am.
Next, we have with us Ayush Agarwala sir. Ayush sir is a partner at Bombay Law Chambers and has more than 16 years of experience in the field of international and domestic disputes, insolvency, and white-collar crimes. Sir has advised leading corporates, financial institutions, and multinational clients on high-value and cross-border disputes, and has also been involved in several landmark cases that have impacted jurisprudence in India. His clients include funds, financial institutions, manufacturing entities, real estate companies, and energy and infrastructure companies. He has worked extensively on arbitration disputes, shareholder disputes, debt-related disputes, construction infrastructure disputes, and environmental disputes. Thank you for joining us today, sir, and making time for this event from your busy schedule. May I please request Janvi to kindly felicitate, sir? Thank you, Janvi. Now I would like to introduce our next panelist, Ms. Shruti Sabarwal ma'am, partner, Shardul Amarchand and Mangaldas. Shruti ma'am is a partner with the firm's dispute resolution practice. She specializes in domestic and in international arbitrations as well as commercial litigations. Shruti ma'am regularly represents and advises clients, both private and state entities, in commercial arbitrations and litigations. She's acted for Indian and foreign parties in arbitration seated in Delhi, Mumbai, Bangalore, Paris, Dubai, and London, and conducted under the auspice of institutions such as ICC, LCIA, SIAC, ICSID, and in ad hoc proceedings. She also acts for clients before various forums, including the Supreme Court of India, High Courts of Delhi, Mumbai, Bangalore, and Ahmedabad, besides others. Her area of focus is the construction and infrastructure industry, power sector, including oil and gas, manufacturing sector, hospitality industry, etc. Thank you, ma'am, for joining us today. May I please request Bhavika to kindly felicitate, ma'am? Thank you, Bhavika. Now I'd like to introduce the moderator for the panel discussion, Dr. Shashwat Bajpai sir. Shashwat sir is founder, partner of DSRB Law Chambers. He has completed his master's degree from the University of Oxford, where he specialized in corporate business taxation and arbitration. He holds a PhD degree from the NLU Delhi in transfer pricing and international taxation. He is a fellow with CIR UK and is on the core committee of the young member group of CIR India. His area of expertise include arbitration, civil disputes, company laws, direct and international taxation, transfer pricing, and telecom law. He has presided over multiple arbitrations as sole arbitrator under the administration of DIAC. We thank you for joining us today, sir. May I please request Mr. Chitragupta to kindly felicitate, sir? Thank you, Chitragupta. Now I would like to request Shashwat sir to kindly proceed with the panel discussion.
Thank you, Sumedha. Very good evening to all at the 4th Arbitration Conclave. I want to thank at the very outset IDRC, Indian Dispute Resolution Center, Devyansh, Sumedha, for having me here with this excellent stellar panel. Without further ado, we have a great panel, so I don't want to take much time, but I must confess, when I saw the topic first, nothing remains unanswered, really, in the arena of institutional arbitration. But when I reread the topic, I came to realize that we are looking at it from a very different perspective. That perspective is accountability. We've often seen pros and cons of institutional arbitration as against the ad hoc arbitration, but this is an area which is less explored as far as some of these seminars and arbitration days and weeks are concerned. When I was reading it, I remembered most of us have seen that Avengers movies, where you have all these stars. I remember one of the verses from Spider-Man movies where they say, with great power comes great responsibility. So it's that responsibility and accountability that we're talking about from an institutional perspective. With that out of the way, let me first start with Shruti, if I may. The basic question which almost everybody asks today, how do institutional mechanisms like scrutiny of awards, appointment of arbitrators, enhance transparency and quality assurance when we talk about institutional arbitrations? Over to you.
Thank you. Thanks, Saraswat. Thank you very much to the organizers to have us here today. A very important question, because there's no doubt that over the past decade, everyone in India, particularly state entities also, have come to realize that the more they go for institutional arbitration, the more likely the outcome will be one which is easy to digest for all parties, whether you're on the winning or losing side. Very often we see, till about a decade back, that all the arbitrations conducted, at least domestically, were ad hoc arbitrations, where foreign parties were in arbitrations with an Indian state entity and they didn't have bargaining power. We were also doing ad hoc arbitrations. Some of those arbitrations are legacy issues which still continue. But there is a change, and the change is because of what you mentioned, institutions coming up with mechanisms like scrutiny of an award or the way they appoint their arbitrators, which does lead to increased accountability. There's no doubt that an award which comes from an institution is much more likely to be enforced than one which is ad hoc. And I sit as an arbitrator in an ad hoc arbitration, and the difference is so stark. There's nobody supervising what exactly is happening. While at an institutional level, if you're sitting as an arbitrator and you haven't written to the parties for 4 or 5 months, there will be someone nudging you to tell you, listen, Miss Arbitrator, you need to do your job. That accountability is something that is increased in institutions. When institutes are scrutinizing awards and they eventually are challenged for set aside in courts, courts do have some comfort in knowing that somebody has looked at this award. Not to say that the reasoning or the merits of the award, but I'll give you an example that I know. I know a gentleman who was sitting in as a sole arbitrator in a matter seated in Doha. This was an ICC arbitration. And the arbitration was concluded, the award was rendered, and it went to the ICC court for scrutiny. There was no comment made to his award, except for ICC informing him that there is a requirement in Doha that you must sign the award while being in Doha, something that had been missed out by him. So the gentleman had to take a flight from Geneva, reach Doha, sign the award at the airport, and took a flight right back. But without that nudging from the institution, without looking at that award, you essentially had 2 years, 2.5 years of work potentially, could have just gone down the drain. So that is why, steps like scrutinizing awards or appointing arbitrators from panels which have certain requirements, they do lead to an increase in accountability, transparency. And the way we're going, I would say, the next 10 years or so, I would be surprised, if we do ad hoc arbitrations anymore.
I think that's a fair assessment that you've put forth, and probably one which many hold. Let's take the flip side of the coin, if I may put this to Madam Dutt. Ma'am, most critics, or at least some critics, argue that institutional arbitration limits party autonomy through their fixed rules and administrative control. What are your views on it, please?
Actually, I'm a little surprised that people say that party autonomy is affected by institutional, vis-a-vis institutional arbitration. Because I'm not sure what party autonomy really is, because it's not that they make the rules. It's the arbitrators who make the rules. And I'm not sure in my 40 odd years experience where parties have had a say in the procedural rules that are being made in an ad hoc arbitration. It's really the arbitrators who set down the rules. And therefore, to my mind, as was said by Shruti, institutions, if you have institutional arbitrations, at least the parties know if there is a panel of arbitrators, what is their background, how many arbitrations they have done, what is the kind of result that has happened. They have an autonomy, actually, freedom to choose from those arbitrators. The rules are known to them. It's not that somebody will sit and say, okay, this is the way I will conduct arbitration. No. There are set rules. So you have these institutions from which you can see their rules, decide which institution you want to go to, which are the rules which are more attractive, more efficient, more transparent, and where you will get what we think is justice. So that, according to me, this is really not a debate in that sense anymore in today's times. Institutional arbitrations should definitely be the rule now. The only thing I would like to add is that, I have been hearing that India should be a hub of arbitration. Now, merely having institutional arbitration is not going to make India a hub. India will be a hub when there is a good, vibrant institutional arbitration, a good, vibrant bar, and the most important, I think, is the Indian judiciary, which is predictable. Because, if you choose Singapore, UK, you know that what kind of award that comes can be challenged. You know your merits. You know where you can lose. In India, unfortunately, there was a saying that equity, long time ago in UK, equity lies in the foot of the chancellor. Now that's where we are, unfortunately. I'm recently seeing, not my case, another case, where arbitration has been conducted in London because two of the arbitrators stay in London. Seat may be India, venue can be anywhere. Cross-examination, opening arguments, everything has happened in London. Now it was fixed for final arguments in London. And the Indian public sector company goes to Hyderabad and gets a stay of the final arguments, saying it should be in India and not in. Now, if this is the kind of judicial interference we are going to have, whatever you may have the best institutional arbitration, India will never become a hub. So therefore, yes, institutional arbitration is the only way forward. We must learn. We sometimes forget to learn from history. That's a big mistake we make even in our politics, etc. Singapore, UK, US have gone through already this phase. They have come up with institutional arbitration, which is very, very attractive, and that's where people go. We should learn. We should learn from their positives. We should learn from their mistakes and move forward. But as I said to you, it requires not only institutional arbitration, it requires a dynamic, transparent bar and a dynamic judiciary, which must also learn from these developed countries which have a very, very dynamic arbitration resolution system. Thank you.
Thank you, ma'am. I think the critics' lips have been sealed with that answer. If I may direct this next question to the learned ASG. Sanjay sir, in what ways can institutions really strike a balance between flexibility to the tribunal versus the institutional procedural discipline which the institutions may cast? So.
Good evening to all. When we are talking about institutional arbitration, the question has been raised. Now, in the first address, various parts have been covered by the co-chairman of Bar Council of India. Now, institutional arbitration, we are talking, on the one hand, we are talking about party autonomy. It appears that they are antithesis to each other, but rightly said by ma'am, that they are not antithesis. Even party autonomy cannot be because party autonomy is for both the parties and they are antithesis to each other because both party has got adverse interest to each other. Therefore, there must be a line, there must be predictability, and unless and until there are set down rules and regulations in which the parties have to act and they know from before, it becomes at times very difficult in ad hoc arbitration. Now, one example I want to give. With respect to fees, the most critical point about arbitration is that exorbitant fees is being charged. I am not only talking about international arbitration. In our domestic arbitration also, the fees has been the most critical point. Now, if it is on the basis of ad hoc arbitration, now one of my friend who was conducting an arbitration, and the arbitrators, there was a panel of arbitrator with a public sector. Now on the first day, one representative went to attend the arbitration. And it was said that you agree for the fees. And instead of fees as per fourth schedule, because it was after post 2015 amendment, in the order it was recorded with consent of the parties, so and so is the sitting fees. There was an appointment of arbitrator by court order, in which it was clearly mentioned that it is under Schedule 4. But with the consent of the parties, it was fixed differently as a per sitting fees, which was very high. So this was the example where when there are no fixed rules and regulations, then the arbitrators at time, they become so arbitrary because it suits their interest. So I am a critique of that, and therefore I say that when the institutional arbitration is at place, the rules, regulations, how it will proceed, the structure, the manner, and the fees, everything is known to both the parties, and they choose how to proceed in the matter. And when it is structured arbitration, then rightly said by Shruti, that even small things are scrutinized before the award is to be delivered. So these things can be minutely looked into, because ultimately if the arbitration award is challenged, then there are very less scope to interfere. Therefore, it is always flexible, better, and it helps in the party autonomy as well, but with fair procedure in that. Thank you.
It's a fair point, sir. In fact, the moment you said fees about the arbitrator, I think we've touched some nerves with the sitting arbitrators. Ayush, we've been hearing the institutional arbitration versus ad hoc debate for a long time. And ma'am has already pressed upon the fact that institutional arbitration is the way forward, which is the majority rule as of date. Now, what key features make institutional arbitrations better equipped to ensure accountability and transparency vis-a-vis ad hoc arbitrations?
Start with an example of a matter that I was doing in arbitration, an ad hoc arbitration. We've had the preliminary hearing. parties have completed their filing, and after that, the arbitrator is not reachable. It's been months. Am I clear? Sorry. Yeah. So, like I was saying, so there's an ad hoc arbitration that I'm a part of. We've had a preliminary hearing. Parties have completed the statement of claim, the pleadings, and the arbitrator is now not reachable for the last few months. I mean, okay, I'm for the respondent, so I'm quite happy. But, and that's where it just comes down to, right? It's accountability. There is administrative control when you have institutions like IDRC, you have institutions like DAC, CAC, MCIA, whatever they are. There is an administrative oversight. There is somebody, like Shruti said, who's nudging you that go on, we need to take the next step. An arbitrator is held accountable. And actually, you will see the same arbitrator, if he was appointed by an institute, you'll automatically see that he's now, adhering to all timelines. He's being more proactive than probably the parties, he or she in question, right? And that's what institutional arbitration brings in. The second bit is the rules that everyone's been talking about now, that everyone before me has spoken. There are set rules. The rules keep getting revamped over a period of time. You've got your emergency arbitrations in place. You've got fast-track arbitrations in place, expedited procedures. CAC now has gone forward, and the latest 2025 rules have gotten certain more procedures which make it, I'm forgetting what it's called, but it's called the streamlined process. In fact, now the streamlined process talks about completing an arbitration within 3 months, obviously up to a certain value. So these kind of things make institutional arbitrations much more attractive than ad hoc, because at the end of the day, with ad hoc arbitrations, we are waiting for the next legislative amendment to come through, right? And finally, quality check. Not only like Datma mentioned about the appointment of the arbitrators, but eventually also about the quality of the awards, and ensuring that they are as likely to be enforceable eventually when it goes down to enforcement and executions. The institution plays a very key role, like Shruti mentioned, in ensuring that the quality of the award is up to the mark and it is as far as possible enforceable in the jurisdiction that it has to be enforced. So I think these are some very key features when we talk about an ad hoc arbitration versus an institutional arbitration, where an institutional arbitration probably trumps ad hoc.
Fair enough. I would love to know who or how the arbitrator was appointed in your example. Was it the court or the parties? That for another table conversation. We've heard from the panelists, and I feel that we've always talked about this change in the Indian arbitration setup for last decade at least, since the 2015 mega amendment. And that puts my next question to Sanjay sir, if I may. Sir, how has the concept of accountability changed with the increasing institutionalization of arbitration which has happened in the past few years, sir?
When you talk about accountability, you see, according to me, so far the quality of the judgment or award is concerned, it cannot be said that there is much difference, because either the arbitrator is a Supreme Court judge, High Court judge, or mostly judges of different courts, or nowadays even some lawyers are also appointed, or technical persons are appointed. But then, of course, so far as the mechanism is concerned, that is how the arbitration procedure is enabled. So it is basically now more justice-oriented procedure is adopted. So that is the only difference which enhances the quality of award, that it is also nudged before the final award comes. Then further question arises that when it is to be challenged. Now the Supreme Court has settled that whenever even then two views are possible, a view which has been taken by the arbitrator is a possible view, then it doesn't warrant interference. So so far as the quality of award is concerned, there is no much difference. But then, how to reach to that quality, there the difference lies. That in institutional arbitration, there is always a chance to get better award because of the procedural betterment as compared to ad hoc.
Thank you, sir. The first word of the topic today is autonomy, a word parties and lawyers hold very close and dear to themselves. With that, Shruti, I wanted to ask you, is autonomy sometimes used to shield the arbitral process from scrutiny? And if yes or no, as the case may be, where do we draw that line?
That's a very interesting question. And it can't be answered without starting by saying that arbitration as an ecosystem doesn't start or stop with the arbitrators and the award. It really has so much to do with the judiciary also. How efficient that process is ultimately comes down to that. How quickly you have your arbitrator appointed, how efficiently you get interim relief in court. All of this contributes to a arbitration ecosystem in that sense. So when it comes to protection of party autonomy, I mean, think of it this way. Before the Perkins TRF range of judgments, party autonomy meant that if you and I were entering into a contract and I had better bargaining power, I would choose the tribunal. Right. So the courts did step in and say, listen, nothing doing. You know, you may be even the government of India, but you're not going to choose who the tribunal is unilaterally. So there are checks and balances in place, and there need to be. I think that's a great example of how, courts have actually drawn that line for us. Another example of this would be two Indian parties today, PASL, having the right to seat your arbitration in Singapore. Till some years back, I don't know if courts in India would have been open to allowing two Indian parties to decide their arbitration there. But then courts have said, listen, if that's what you want to do, you do that. That's your autonomy. But then you're going to enforce your award here as a foreign award. You will go under Part 2 of the Act and deal with whatever comes with that. Though, I mean, frankly, it's so much more efficient. I don't know why more parties don't do it. But yeah, so I mean, there is a line to be drawn. It is for courts in most situations to draw that line. And very honestly, I think courts in India are doing a great job. Sometimes we're one step forward, two step back. That happens. I mean, ma'am, you're talking about that, getting a stay of that arbitration in London. I'll tell you, last year I tried to get a stay of an arbitration in Africa, and I didn't get it. So it also depends what court you're going to in India. Makes a big difference, but yes, that should not be.
Predictability should be there.
So all in all, there is a line to be drawn, and I don't think that line can be drawn without court intervention. But it's like ma'am said and sir said, it's about, that predictability, that, courts across India should sort of be on the same page, because otherwise we're so used to having diverse views. Everything has to wait to go to the Supreme Court, then the Supreme Court will settle it, then it'll change everything. So, but still, that line is being drawn, and I think the courts are doing a decent job at it.
Thanks, Shruti. We've seen in the past 5 years, especially during the COVID times and since then, innovations have come up. I'll put this next one to you on that, Ayush. How do innovations like expedited procedure, digital platforms, emergency arbitrations, and so on and so forth impact this autonomy accountability equation?
I think it's more of, yes, there is a little bit of accountability, etc. in it, but I think it's more of efficiency and enforceability that really comes in over here, right? And I think being efficient is also a part of being accountable. As an arbitrator and as an institution, you have to be accountable for the conduct of the arbitration, and efficiency is a very important part of it. And all of this helps with efficiency. For example, your emergency arbitrations. In an ad hoc situation, in an ad hoc arbitration, you would have to go to court. While some courts are good, there are certain courts that you would like to avoid. Now, that may be possible in good in high value, good complex arbitration and commercial agreements. But then there are agreements. We are a large country. Agreements being entered into in multiple states and multiple regions, right? That's number one. Number two, you would talk about, when we talk about efficiency, we also look at something like, sorry, I think I'll stop with that because it is efficiency. So you have emergency arbitrations. Sorry, we spoke about digital platforms. Yes, that is what I was missing. So digital platforms. With digital platforms and the acceptance of digital platforms, you have something as simple as your transcribing platforms, right? Everything that is done during the course of the arbitration is recorded somewhere. And that is very important for autonomy. That is very important for accountability. That is very important for efficiency as well. The same goes for your expedited procedures, efficiency. I think it's more about efficiency rather than accountability or autonomy, honestly.
Thank you. I think that's a fair assessment. And as we've heard from the panelists, I feel institutional arbitration does offer a structured path forward. They combine flexibility and, as we've heard, administrative support, importantly the nudging, as Shruti rightly pointed out. In fact, Indian arbitration institutions are also doing very well. IRDC, as a matter of fact, as I know, have been doing brilliantly along with other institutions like DAC and MCIA. Now with that, Shruti, if I may put this to you, what lessons can these Indian arbitration institutions draw from international arbitration institutions like CAC, LCIA, ICC, again, from the perspective of accountability and autonomy?
I think one thing is, of course, processes such as, an institution can choose whether it would like to take the step of scrutinizing the award, whether it would like to, how it, nominates its panel, who is its panel. If the panel is just people you know of, then that's not an institute that's going to survive in the long run. And like we've seen in the draft bill, institutionalization of arbitration, there's no escaping it. But having said that, I was looking at just the IDRC rules themselves, and they're fairly forward. They have a rule in place for early disposal of matters. They have emergency arbitration. Even the disclosure requirements for IDRC is fairly at par at an international standard. So the idea is to, I guess, not stagnate, keep yourself abreast with what is happening at an international level, like we saw MCIA do, revise its rules to bring it up to speed with what is happening at an international basis, whether it was introducing emergency arbitration. So it doesn't have to be innovation always, but as long as we're adopting best practices for institutions in India, I mean, there's nothing stopping us really.
Well, I do feel Indian institutions are running shoulder to shoulder with the international arbitral institutions. Madam Dutt, if I may put this to you, and this is often the question posed in many arbitrations, days and weeks, as we've heard. Should there be a universal benchmark or accreditation for the arbitral institutions to enforce and ensure that this uniformity, transparency, and accountability actually does happen?
I think it's a very good idea. I think I saw that there's a section 43 introduced, notified, but it hasn't come into effect. The only problem I have with that provision is there is too much of government interference in it, which I'm not sure is the best practice, so to say. But yes, see, if you put out that these are the arbitrators, this is their background, this is what they have done, it always helps. Actually, it's a party autonomy. Then you have a right to choose out of that panel who you think is best suited for your kind of problem that you want to invoke arbitration. Please remember, arbitration is an alternate method to get justice. What do we go to courts for? To get justice. Why are we now looking to arbitration? Because courts take a lot of time. There are too many cases. We have a population which is quite unmanageable. And therefore, when we are looking to arbitration as an alternate to give justice, we must have an extremely transparent system so that people can choose what they want and they get what they choose. You know, that's important. And as I said, that, you know, you also asked what's the difference between 20 years ago. Now, we are all developing. So, once you develop what I could do 20 years ago, today everybody is under scrutiny. Every judge, every lawyer, what happens in court, you are under scrutiny. So why should arbitrators not be under that? Therefore, if institutions come out with, you know, this is the list of arbitrators, this is what they have done in the past, this is the time taken during that arbitration, what happened to that award, I think will actually boost party autonomy.
It's so interesting you say this because I have a case which is pending in the 34 stage, not in High Court of Delhi, where the principal ground taken is that the advocate who appeared as counsel in that matter was also on the panel of the institute in question. So now these kind of grounds are very novel to India. That, oh, so-and-so is on the panel, you've publicized him or her as an arbitrator on your panel, so therefore there must be some bias. We're very quick to use the principles of natural justice as a ground for anything. So it is something, like I said, the ecosystem has to go hand in hand. And like you said, ma'am, about the accreditation, I mean, it's scary. If I was running an institution, I would think twice if the government has to decide whether I'm A category or B category, how many awards go against the government? Of course, there's no escaping that. So there has to be a better way maybe, you know, to come to this. That's.
Well, ma'am said we get what we choose, so I'm not sure the audience will say what they chose about the panelists here, the five of us. If I may put this to Sanjay sir, and from a different perspective, we've been talking about the institutional arbitrations, both in comparison to the ad hoc arbitrations and the other international arbitration institutions. How can Indian courts, how can courts in general, support these institutional arbitrations without, of course, encroaching the autonomy? Over to you, sir.
The very simple answer of mine will be that when an application is filed before the court under section 11(6) for appointment of arbitrator, instead of making appointment ad hoc arbitrator, it should direct that the party should approach for institutional arbitration. And since it has got its own advantage, so it will always be, there will be no encroachment in the party autonomy. At the same time, the institutional arbitration will be promoted, and nobody can raise finger on that. Because you see, one fact I wanted to add was that we talk about the arbitration and the stage of arbitration and award. Our problem in this country is, now we don't talk of Delhi only. Now if we talk of different states, now the award passed by a retired Supreme Court judge or a High Court judge is challenged before a principal civil judge in the district. Now, as a lawyer, I had seen the district judges had no guts to pass an order if they wanted to interfere or even not to interfere. The result is that they are keeping the proceeding pending till they get transferred or they get promoted. The result is that even though the award is passed, but the party in whose favor the award has been passed does not get the fruit of the award, and it remains pending for years together. So this is one. So if there is institutional arbitration with all predictiveness, and then since in the institutional arbitration the arbitrators are considered with all check of background, So there will be lesser scope of interference, and then at least that a message will percolate down the line that the Supreme Court has said about least interference in the award, so we should at least decide it at the earliest. So that will help in that manner.
Fairly put, sir. Fairly put. Ayush, now the million-dollar question to you, which has been vociferously asked from several panelists and several platforms. How do we make institutional arbitrations more accessible and affordable, of course, while maintaining its integrity under the principles of autonomy and accountability?
I think, like the learned ASG just mentioned some time back, I think a lot to do with institutional arbitration or arbitrations in general is costs, right? The moment costs are on the check, it becomes very accessible. That's the first step towards accessibility, right? And I think at least Indian institutions are doing a good job of keeping that under check. I don't think it's really going overboard. The costs related to an arbitration is not really going overboard when an Indian institution is involved. And I think some foreign institutions are also following suit. That's number one. Number two, I think another way of doing it is involving more and more or increasing the diversity of the arbitrators who are empaneled in institutions. When I say increase in diversity, I mean there should probably be more sector-specific or technical or arbitrators with more technical knowledge involved who can be appointed for certain technical kind of arbitrations. Get younger lawyers involved. Some institutions are doing that. In ad hoc arbitrations, some judges and some courts are favoring involving or appointing younger lawyers as arbitrators. I think all of this makes it more accessible. And finally, I think institutions need to figure a way of becoming a little more, I don't know, would you call it marketing? It's not really available or known to people across the country, right? I'm in Delhi, I practice in Bombay, we are in Delhi, and certain other metros are really aware about institutional arbitrations, right? But what happens when you go, and this is very specific to a place like India, right? Because again, we are a very large country. What happens when there's arbitration, when there's a requirement for arbitrations in smaller towns or in far-reaching towns? I think that's where institutions need to really make an effort to reach out to those places. I'm not sure what the right way of doing it is, but then there has to be some way of doing it. For example, we were doing an arbitration now, or we were conducting a challenge to a Section 9 order, but falling out of a SIAC arbitration. The senior counsel who was appointed for this, and ideally a very good senior, I had a great time briefing him, but I had to first take him back to explain to him what institutional arbitration is and how it works. So that's exactly where I think institutional arbitrations or institutions really need to apply their minds. They need to figure out a way to be more approachable in the smaller towns and in the farther regions in India.
I want to add something.
Yes.
Rightly our friend said, like we are sitting in Delhi, but then arbitration is required not only in Delhi or Bombay or Calcutta, but at small places also, like railway organization. Now railway has got organization across the country in small places, small towns also. There are contracts awarded and dispute arises. And then ad hoc arbitration is used normally. But then if, I think rightly said by you, that institution should try to reach out even to small places where if we make it strong, then that will go a long way and help to the people across the country to get the benefit of arbitration and this act. Recently, I had the privilege of attending a similar conference and panel discussion on mediation in Bhubaneswar It was attended by large number of Supreme Court judges, Chief Justices, and they discussed on this subject also, which is now growing. But even the arbitration which has now set across the country, but still the institutional arbitration has not reached to the district towns, which it is required badly to have a better and effective arbitration.
And it's important just in this context, over the last year, I think there's at least 2 or 3 opinions we've given on clients who have asked us, particularly NBFCs and sorts who have a large volume, all arbitration, but the quantum may not be so big. But everyone, I mean, we are all good, we're counsel, there's judges, but we're not actually the users of this process. So the guy who actually needs it is asking now, what about ODR? I'm sick of your arbitration also. You tell me automated ho sakta hai kya? Award mil jayega kya? So this is the reality. So and places like MP and Gujarat, they have their own legislations. For if you do public work there, you're bound to do arbitration per the tribunal set up there. And so interestingly, all of these acts have been constitutionally challenged but upheld. So the diversity in India can sometimes work both ways. It's great, and then sometimes you have to deal with these eccentricities.
Thank you to both for your comments. Madam, if I may have your last word. One reform, if you would want to choose to enhance the accountability process without, of course, sacrificing autonomy, what would that be under the institutional arbitrations?
I think what you mean by accountability of arbitrators is probably their appointment process, their disclosure process, the way they conduct the arbitration, and the award that comes out. These are 4 aspects which require us to concentrate on. But I will again say these are not sufficient. You need a bar which is far more vibrant and not part-time that I'll do morning, I'll do court, and evening I will do arbitration. Secondly, I should not be misunderstood, but appointing arbitrators only retired judges is not, in my view, the way forward. And lastly, as I said, we have to have a predictable judiciary. They have to be trained. As I said to you, you go anywhere in the world in a developed country, you know whether your award will stand scrutiny or not. In India, you just can't say, because you don't know which judge, as somebody said, you will get. That should not be. If we can, look into these aspects and provide meaningful answers to them and not knee-jerk reaction, because what I see is every 2 years there is an amendment. I mean, it can't be, that's not the way to function, that you have knee-jerk reactions, something comes and then you start legislating. You have to think through these things, legislate once for all. I'm not saying it's not, if something new comes up which is really dramatic, yes. But otherwise you must sit down, think through all these aspects, and then I think only then India can become a hub of arbitration. Till then, it's not possible. I don't see any foreign arbitration. In fact, I'll give you an example. There is an arbitration in Singapore, but it's under Indian law. Now, there is no institution in India. We have foreign arbitrators who will act as fund controllers. None of them. We approached several, including DIAC. They don't have it. Whereas if you go to SIAC, so those arbitrators are saying, do we come to India and go run to various courts to get our fees? So these are, you have to think holistically and bring about amendments which cover every aspect, as I said, from appointment to judiciary. And that's the way forward. And of course, as I said, party autonomy is institutional arbitration. It's not separate from that. Thank you.
Thank you, ma'am. Thank you very much. Just to end, I was reading a book maybe a week earlier on. It was someone referring to Mahatma Gandhi's writings on self-rule and Swaraj. And I cannot but state that line. He said, true independence is being accountable for one's choices. So what we've heard for the last 1 hour and what we've seen for the last decade, I think we have responsibly parted with our autonomy and choice over to the institutional arbitrations. And now we urge them to use this power, responsibility. I'm talking about accountability. I, as a moderator, am accountable to finish this on time. Justice Manmohan is there, Honorable Minister is there. So with that, we thank the panelists. Please, sir, please.
I just want to make 2 points. Now, the example which I gave, that when an arbitrator is a judge of either the Supreme Court or the High Court, and his award is to be challenged before the principal civil judge in a district court in a remote area of the country. Now, he doesn't have that guts to interfere. So we need some interference and amendment in this law so that at least it can be challenged before a high court, like it is in Delhi in original jurisdiction, but it is not there in other parts of the country. So this is one aspect which we need. Now, another important part is that so far award is concerned, till the arbitration award is passed, time is fixed. By that time, the award has to be passed. But thereafter, when the award is challenged under section 34, and thereafter 37, no time is prescribed. So it continues. So therefore, we need to have some amendment on this front also, so that predictability will come, that a person will get an award by this time. Thank you.
Thank you. With that, we don't have time for questions. I'm sorry, but we thank the panelists, and over to you, Divyansh. Thank you.
Thank you, sir. I would like to thank our esteemed panelists for such an engaging session. I'm sure the positive exchange of thoughts will help us take concrete steps to make India a hub of institutional arbitration. I would like to extend warm gratitude to our panelists S.G. Sanjay sir, Anuradha ma'am, Ayush Agarwala sir, Shruti ma'am and Shashwat sir for sparing your precious time and joining us today and being part of the conclave and for your support. Now I would like to request our panelists to join us for a group photograph. And I would like to request, we have in our amidst Honorable Law Minister Arjun Ram Meghwal sir and Honorable Justice Manmohan to please join us on the stage as well for the group photograph. I would like to request O.P. Dhankar sir also to please join us on stage. IDRC team can please also join us on stage. I would like to request Honorable Law Minister and Justice Manmohan to please stay with us on the stage. For the valedictory address, we have with us Honorable Union Minister of Law and Justice, Shri Arjun Ram Meghwal sir. Now I would like to introduce sir. Arjun Ram Meghwal sir was appointed as Union Minister of Law and Justice in May 2023 and has retained the post after 2024 general election. In this capacity, sir has been responsible for implementing major legislative initiatives such as the 3 new criminal laws that came effect last year. Sir, after clearing the Rajasthan Administrative Services examination in 1980, was promoted to IAS officer in 1999, from which he later took voluntary retirement to enter politics. Meghwal sir represents Bikaner constituency as Member of Parliament since 2009 and has been previously Minister of State for Parliamentary Affairs and Heavy Industries and Public Enterprises, Minister of State for Finance and Corporate Affairs, and Minister of State for Water Resources. He was awarded the award for Best Parliamentarian in 2013. It's an honor to have you with us, sir, today. I would like to invite Shri Om Prakash Dhankarji, National Secretary, Bharatiya Janata Party, former Minister, Government of Haryana, and former State President, BJP Haryana, to felicitate Meghwal, sir. Thank you, sir. Now I would like to request Honorable Law Minister to deliver his keynote address. Sir. जी sir. Thank you, sir.
अभी तो हम आकर के एडजस्ट ही नहीं हुए, उससे पहले ही बोल दिया आपने तो। थैंक यू जी। मंच पर हमारे ऑनरेबल जस्टिस मनमोहन जी, हमारे परम मित्र और हमारे साथी, हमारे पार्टी के पदाधिकारी ओपी धनखड़ साहब, एसडी संजय साहब को भी सुन रहा था, हमारे एडिशनल सॉलिसिटर जनरल ऑफ इंडिया है, अनुराधा जी को भी सुना मैंने अभी यहाँ बैठे बैठे, राठी साहब और सभी को नमस्कार करते हुए मुझे कुछ 2-3 चीज़ें इस संबंध में कहनी है। आप ये जानना चाह रहे होंगे कि भाई सरकार का क्या रुख है या सरकार का क्या मत है, ये सबसे बड़ा विषय है। देखिए, अभी परसों हमारी एक एससीओ समिट थी, संघाई कॉरपोरेशन ऑर्गेनाइजेशन, जस्टिस मिनिस्टर, लॉ एंड जस्टिस मिनिस्टर्स की एक कॉन्फ्रेंस थी, ऑनलाइन थी। रशियन डेलीगेशन वाले इसको लीड कर रहे थे, मॉडरेटर भी वही थे, एक उनका सेक्रेटरी जनरल था, वो उसको बीच बीच में कुछ कह रहा था। रशियन, चाइना के लोग, अफगानिस्तान, पाकिस्तान, किर्गिस्तान, तजाकिस्तान, उज्बेकिस्तान, अफगानिस्तान, ईरान, ऐसे देशों के लॉ मिनिस्टर थे। उसमें एक चीज़ कॉमन मैंने देखी, एक तो उनका कॉमन एजेंडा लीगल एड टू द पुअर है, दूसरा उनका कॉमन एजेंडा देखा, हमारा भी भाषण था तो हमने भी अपनी बात कही, लेकिन उनका भी एक कॉमन एजेंडा था सभी देशों का कि हमें एडीआर के कंसेप्ट को आगे बढ़ाना पड़ेगा। और आज की जो ये कॉन्फ्रेंस है, मुझे लगता है उसी दिशा में एक बढ़ता हुआ कदम है। उसके लिए बधाई आयोजकों को, बहुत बहुत धन्यवाद, शुभकामनाएं। और वो सभी देशों के लोग कह रहे थे कि एडीआर के कंसेप्ट को इसलिए आगे बढ़ाना पड़ेगा, अल्टरनेट डिस्प्यूट रिजोल्यूशन मैकेनिज्म को, कि कोर्ट केसेस बढ़ गए, सबके यहाँ ये प्रेशर है कोर्ट केसेस का, डिस्पोजल कैसे हो, तो एक अल्टरनेट डिस्पोजल मैकेनिज्म को हमें लाना चाहिए। हमारे यहाँ पहले से ही था। अगर मैं पहले से बात करूं, धनखड़ साहब मुझे एग्री करेंगे, हमारे लॉर्ड कृष्णा मीडिएटर ही थे और क्या थे, क्यों संजय साहब? हाँ, गांव में पंच पंचायती होती थी तो आर्बिट्रेशन से जैसा ही काम करते थे वो। हमारी कल्चर का ये पार्ट रहा है, आर्बिट्रेशन, मीडिएशन, कंसिलेशन। हम आपस में बैठ करके समझौता करते थे, मानते थे, हमारी संस्कृति का भी पार्ट रहा, लेकिन बीच में जाके कहीं अटका। लेकिन अब ये आ रहा है कहीं सिंगापुर से, कहीं दुबई से, कहीं लंदन से, कभी हांगकांग से, और हमारी डिमांड आ रही है कि हम उन जैसे क्यों नहीं बन सकते। तो आपने सही कहा, अभी अनुराधा जी जो कह रही थी सही कहा, कि अगर हमें आर्बिट्रेशन का हब बनना है तो हमें कुछ अमेंडमेंट करने पड़ेंगे हमारे एक्ट में। हम आपकी बात से सहमत हैं, जल्दी इसको आपको कुछ देखने को मिलेगा, विशेष करके सेक्शन 34। लेकिन संजय साहब ये बताइए, एक विषय बार बार ही आ रहा है, जुडिशियल इंटरवेंशन कितना होना चाहिए? होना तो चाहिए। आपने अभी सुझाव दिया कि आर्बिट्रेशन के अवार्ड को जब कोई आदमी चैलेंज करता है तो बाद में चैलेंज करने के लिए प्रिंसिपल जज या डिस्ट्रिक्ट जज के पास जाता है, वापिस वो नए सिरे से सुनवाई करता है, फिर वो देखता है सुप्रीम कोर्ट का फैसला है, इसमें इसने बड़े जो जज रहे उसकी ओपिनियन है, तो बड़ा अलग तरह से वो सोचता है चीज़ों को। तो आपका सुझाव भी इस दिशा में अच्छा सुझाव है, और आज आप कुछ मंथन करिए। आज का दिन भी बहुत बड़ा है, सरदार वल्लभ भाई पटेल जी की आज 150वीं जयंती है, बड़ा दिन है। वो भी एडवोकेट थे साहब। हाँ, बहुत कम लोगों को पता होगा कि उनकी बेटी ने कोई किताब लिखी अपनी मां पे। बहुत कम लोगों को शायद जानकारी होगी कि 1909 है शायद एग्जैक्ट, अगर 1909 आनंद में सरदार पटेल साहब बहस कर रहे थे एज एन एडवोकेट। उसी समय उनके पास एक पर्ची आती है, उस पर्ची में सूचना होती है कि आपकी पत्नी की डेथ हो गई। बिना विचलित हुए, बिना वो जज भी अंग्रेज था, भाव भंगिमा से पता नहीं लगते हुए भी बहस जारी रखी, और बाद में जब पूछा जज ने कि आप विचलित ही नहीं हुए, आपकी पत्नी की डेथ हुई है, तो उन्होंने जो जवाब दिया वो बहुत जोरदार जवाब था, मुझे अभी याद आ गया इसलिए मैं कह देता हूं। उन्होंने कहा मेरी पत्नी की लाइफ तो वापस आ नहीं सकती। ये जो 46 लोग हैं जिनको आप डेथ पेनल्टी देने वाले थे, इनकी लाइफ में बचा सकता हूं, इसलिए लाइफ और न्यू लाइफ में आपको फर्क करना पड़ेगा। उनकी लाइफ तो वापस नहीं आ सकती, लेकिन इनको मैं न्यू लाइफ दे सकता था और वो आपने दी। वो जज भी प्रभावित हुआ, छोड़ दिया उनको। 46 थे, 46 किसी केस में, वो सब बच गए। तो उसी को लिखा मणि बेन ने कि देयर इज ए डिफरेंस बिटवीन लाइफ एंड न्यू लाइफ, और सरदार साहब ने इसको, और आज के दिन ही आपने ये इंडियन डिस्प्यूट रिजोल्यूशन सेंटर के द्वारा हेल्पिंग गुड पीपल रिजॉल्व, मैं डेटा आज ले नहीं पाया, लेकिन बहुत से ऐसे मामले हैं जिनमें पैसा फंसा हुआ है। अगर हम इसको आर्बिट्रेशन से, मीडियन से रिजॉल्व करते हैं तो वो पैसा खुलता है, इकोनॉमी में आता है। इकोनॉमी में आता है तो इकोनॉमी जनरेट होती है, और इकोनॉमी जनरेट होती है तो जो हम सोच रहे हैं कि आने वाले समय में ये 21वीं सदी भारत की हो, ऐसी एक कल्पना है। और आपको भी सबको जानकारी है कि अगर थोड़ा पीछे नहीं जाएं, लेकिन 2 सदी पीछे चलो, 19वीं सदी, ये सदी अधिकतर ऐसा लोग कहते हैं, जो तय करने वाले लोग होते हैं वो कहते हैं ये कॉन्टिनेंट की होती है। उसमें कोई एक देश लीड करता है। तो 19वीं सदी के बारे में हम सोचें तो यूरोप की थी और यूके ने लीड किया। 20वीं सदी के बारे में हम सोचें तो वो नॉर्थ अमेरिका की थी और यूएसए ने उसको लीड किया। 21वीं सदी के बारे में हम सोच रहे हैं, और हम नहीं कह रहे हैं, वही यूरोपियन लोग ही कह रहे हैं, जो रणनीति बनाने वाले लोग हैं, वो कहते हैं 21वीं सदी एशिया की होगी। लेकिन नहीं आप चाहते कि भारत लीड करे? चाहते हो ना? तो ये जो आपने आज टॉपिक दिया, हेल्पिंग गुड पीपल रिजोल्व, लड़ते रहते हैं। लड़के ने पिता के खिलाफ केस कर दिया, एनर्जी चली गई। भाई भाई के खिलाफ केस हो गया, एनर्जी चली गई। 15-20 साल लड़ाई चल रही है। एक बड़ा अच्छा इंटरवेंशन हुआ कॉमर्शियल कोर्ट का, जिसके कारण हमारे कॉमर्शियल कोर्ट सेटल ठीक होने लग गए। लेकिन इसमें ये आर्बिट्रेशन मीडिएशन एक्ट में हमने एक अमेंडमेंट किया 2023 में, और अब उसमें जल्दी ही हम एक मीडिएशन काउंसिल ऑफ इंडिया बनाने की दिशा में कदम बढ़ा रहे हैं। और आर्बिट्रेशन काउंसिल ऑफ इंडिया बनाने की दिशा में भी कदम बढ़े हैं, लेकिन एक बीच में ये अमेंडमेंट वाला इशू आ गया। एक तो ये सेक्शन 34 वाला आ गया, एक कंपनी के जो डायरेक्टर, उनको लेकर के सुप्रीम कोर्ट का एक ऑब्जर्वेशन आया, उसको लेकर के कुछ उसमें विवाद भी हुआ, और वो भी एक विषय चल रहा है। तो हमारे एक कमेटी के पास है वो, तो जल्दी हम इस आर्बिट्रेशन एक्ट में अमेंडमेंट की दिशा में कदम बढ़ाएंगे, और जो आपकी भावना है उस भावना के अनुरूप ही हम भारत को आर्बिट्रेशन, मीडिएशन और कंसिलेशन का हब बनाने की दिशा में महत्वपूर्ण कदम उठाने वाले हैं। इतने ही मैं कह सकता हूं। आज के इस पावन अवसर पर आपने मुझे बुलाया, बोलने का अवसर दिया, उसके लिए बहुत बहुत धन्यवाद, शुभकामनाएं, आभार। थैंक यू।
Thank you, sir, for sharing your insights on the arbitration environment in India and initiatives and steps taken by the Government of India to promote India as a hub for institutional arbitration. It's a pleasure and honor to have you with us today, sir. Now, I would like to introduce Honorable Justice Manmohan, sir, Judge, Supreme Court of India, who has joined us to deliver the valedictory address. Lordship enrolled as an advocate with the Bar Council of Delhi in 1987. He practiced in the Supreme Court of India and High Court of Delhi in civil, criminal, constitutional, taxation, arbitration, and intellectual property right litigations. Lordship was designated as a senior advocate in 2003 and was elevated as an additional judge of the High Court of Delhi in 2008 and appointed as a permanent judge in 2009. As Honorable High Court Judge, Lordship delivered a number of significant landmark judgments. Lordship was appointed as the acting Chief Justice of Delhi High Court and thereafter as Chief Justice of the Delhi High Court before his elevation to the Supreme Court of India last year. It is our honor to have you with us today, Lordship. I would like to invite Divyansh Rathi, Honorary Secretary, IDRC, to felicitate Lordship. Thank you, Divyansh. I would like to now invite Lordship to deliver the valedictory address.
Respected Shri Arjun Ram Meghwal ji, Law Minister, Union of India, Mr. Divyansh, Ms. Menon, distinguished ladies and gentlemen. It's a very difficult act to follow Mr. Meghwal because he can directly communicate with the public at large. And you know, when I was a lawyer, I had that capacity or that capability, but now that I am a judge, I don't regularly interact with the public. That magic has gone, that connect has gone. But I'll try to do my best. First of all, I would like to thank the organizers for inviting me to put my view across to you In fact, it was a pleasure meeting Divyansh a few days back. He informed me that the Indian Dispute Resolution Center has been established in 2020. That's only 5 years back, and it's the first non-institutional non-institutional arbitration and mediation center which is registered with the Ministry of Law and Justice, as well as with Niti Aayog. It provides arbitration dispute resolution mechanism to the government, to the public sector undertakings, and it provides state-of-the-art institutional environment both for offline and online, because today the online is the basic buzz, and it uses its cloud-based e-ADR program. It has conducted, I'm told, more than 3,000 arbitrations in the last 5 years. No doubt it is positioning itself as a global hub for institutional dispute resolution, but its story is very inspiring. I would agree with the law minister that its success is because of the roots, because of our history, and our history is embedded in arbitration and mediation. As he pointed out, Lord Krishna was also a mediator in Mahabharata. So we have a long tradition going back to our Gaon Sabhas, our panchayats, and they have done phenomenal work. In fact, you'll be surprised that panchayats are so powerful that they can even settle a criminal matter, including a murder matter. You'll be surprised their power, what their power is. So our ancient system was a fair system where justice was delivered quickly in an expedient manner and at very low cost. In fact, there was no cost attached to it. But now life has become a little more complex. There are a lot of businesses which have come. So a structured mechanism has to deal with it. That was the courts. But the courts also became overflooded with dockets. There's just too much of litigation going on in courts at the moment. Maybe the judge population ratio is also not very good. We have very few judges for the large population that we have. But the real problem is in commercial litigation, where people require a resolution. And as the minister said, that if India has to become a Viksit Bharat in 2047, then you need a very good dispute resolution mechanism. In fact, when major investors are coming and taking a call where to invest, which country to invest, the first thing they ask is, how will our disputes be resolved? What is the dispute resolution mechanism that this country has? How effective and efficient are its courts? Or if not the courts, where can we go to? And really, that's how the arbitration story began in India. And as we have seen over the years, we had the Arbitration Act 40, then we had the 96 Act, which was modeled on the UNICITRAL laws, which has brought about certain amount of credibility and uniformity. But it also was embedded in some problems. And the problems are that there is a lot of delay and a lot of high costs. The procedure that was adopted in these arbitrations and that is still being adopted in these arbitrations is actually a mirror of what is happening in the courts. People are looking for an alternative, not for a photocopy of a court proceeding, and unfortunately it has become that. The hearings, as we know, in the arbitration are getting repeatedly adjourned because either the lawyers are not available or the arbitrators are not available. And as was being pointed out by the lawyers themselves, there is no dedicated bar as such, in the sense where lawyers only practice arbitration. They don't go to court, they believe in the alternative dispute resolution mechanism. And the other challenge which the arbitration faced was, how do you get a neutral or a fair arbitrator? Because people were saying that one of the parties is retaining the power of appointment of an arbitrator, and once that arbitrator is appointed by that authority or that party, the arbitrator tends to favor the appointing party. There, I think the Supreme Court laid down very landmark judgment, starting from Perkins to Court 2, and they said that no, there cannot be a unilateral appointment by one of the parties to the dispute. And that, I think, was very important, because the issue of bias which is embedded in the arbitration needed to be addressed, and that to some extent has got addressed. Then the government also set up a committee, that B.N. Sri Krishna committee, which gave very good suggestions with regard to arbitration. And its major recommendation was, if you want to move forward, institutional arbitration is the answer. And I think the institutional arbitration is very, very important and a very significant step towards resolution of disputes in an expeditious and a fair manner. And why do I say that? I think the institutional arbitration has some distinct advantages. One is that it comes with the rule book, because the institutions have their own inbuilt rules. That is very important. That is the soft law which you get with the institution. The second advantage is that they have a specialized staff that monitors how the pleadings are completed, how the matter is taken up by the arbitrators, what is the schedule for the arbitration. Third is that, you know, when the award is rendered, that is, there is a slight amount of check and balance which is done by the institution staff. I still remember that many years ago, when I was a lawyer and we were doing a very important arbitration, and it dealt with valuation of items, one of the mistakes which the steno committed was that while the items were being valued, most of them were in lakhs, but some were in crores. The steno committed a mistake. He added a 0, and that gave a handle to the other party to argue for hours in court that there was total non-application of mind by the arbitrator. And the matter went in a tizzy, because they said, how can an item which is valued by both the parties in lakhs, the awarded sum be in crores? But that was just a typographical error, and a lot of time was spent on that. So if these sort of mistakes are cured at the arbitration stage by the institution staff, I think it will greatly help the arbitration movement. Then, you know, the institution also serves as a think tank, because people who come over here, normally they have seminars like the one that you are having today. That, I think, is a great advantage, because people are coming to know about the significance of the arbitration. This is one of the important duties which the institution performs, of calling people from different cross sections, calling different stakeholders, and having a discussion with regard to the arbitration movement. It is a pleasure to hear the law minister say that yes, we are examining the functioning of the act, and whatever changes are required will be done in the immediate future. That is really significant, I think, to my mind. And this is the sort of openness, the discussion which must take place if we have to improve the system. And I think that is the intent of this. There is also a concern about cost, which I heard in the previous session that was being talked about. And you know, I attended one of the sessions of the ICC arbitration, where we were discussing about the ICC. And they said they did a survey, and they found that the institution's cost was on an average about 2% of the overall cost, and the majority of the arbitration cost, that nearly 82%, was the lawyer's fees. So it is not the institution's cost that should deter institutional arbitration. And they found that 16% was the arbitrator's fees, but really the significant portion went in the lawyer's fees. So institutional cost is not much. Normally the institutions keep their costs in check, but somehow we find that even today it is the ad hoc arbitration which is the most popular arbitration in India. Really, that has to change. I am of the view that, you know, there should be a legislation which should just prohibit ad hoc arbitration for some time. And I think the minister can consider it, but I leave it to him. It's a drastic suggestion, but it may not be bad. Really, this movement needs to be strengthened, and this is the right way forward. The other point is that, yes, the courts must support arbitration rather than acting as a barrier to arbitration. In fact, in one of the matters which I was hearing, where an eminent senior counsel was arguing, and he told me, sir, do you know that in France, if an arbitration award has been rendered, it can be enforced even if it has been set aside by a court. So, of another country. Meaning thereby that if there is a commercial award, a foreign arbitration award, which has been rendered, it has been set aside by that municipal court saying it is in violation of principles of natural justice or anything, but you can still go to France and get it enforced. See, this is the other extreme some countries have gone, where they do not accept any interference by the courts, because they consider it to be an alternative dispute resolution mechanism, alternative to the court system, so they don't want the court interfering with it. Really, we have to think hard. What are the parameters of 34 going to be? Is it going to be just because it appeals to my conscience that this award needs an interference, or is it something more? See, there was a very famous case many years back where there was the Arab-Egypt war, the Egypt-Israel war, and many US corporations were executing large contracts in Egypt, and the US government declared Egypt to be a hostile country and virtually said you cannot conduct business. So the US corporations stopped conducting business, and awards were rendered all over the world against US corporations, and they were sought to be challenged on the ground. What can we do? The government has prohibited us, we can't do anything. And the US court said that that is not opposed to public policy. It has to be something more. Now, if you have to accept the world that we live in, we have to ensure that arbitration awards are not interfered with at the drop of the hat. Yes, there has to be consistency, there has to be predictability. And that really is at the heart of the arbitration movement. One issue I would like to flag, because the law minister is here, and that I do it as a person who believes in arbitration, is the new circular that the Ministry of Finance has issued, that above 10 crores, no dispute will go for arbitration. Really, I would request the minister to re-examine it. I don't blame the view or the stand which the government has taken. Maybe they have good reasons for it. Maybe they have good reasons. They must have done their own research. They must have got the wrong end of the stick, I guess, in some arbitrations. I can understand that. But government is not only a major litigant, but it is also the constitutional arm which has the power to amend the act. So whatever is their issue, they must resolve it by using their power appropriately. But they cannot ignore the arbitration movement, and they should be a part of the arbitration movement, is my view as a lawyer, not as a judge. So I would request the law minister to consider it, and really the way forward is only through institutional arbitrations. If we can give it a fill up, if we can ensure that we have good institutions which meet the international benchmarks, and there must be enough competition between these institutions. There should not be just a monopoly of one institution. There should be many institutions. And why should they be only for international commercial arbitration? Why not for other matters, for other disputes? Or for smaller commercial disputes? For instance, the Automobile Association can have its own arbitration center. See, if you want to give a fill up to the business moment, you want to attract investment, you will have to ensure that disputes are resolved immediately at the drop of the hat. Some disputes cannot wait. For instance, whether it's construction of a bridge or infrastructure, that really will have to be resolved quickly. In conclusion, I would like to only say that we need many more institutions like the DISC or the IDRC to ensure that the promise of accessible and timely justice for all becomes not just an aspiration, but a reality. Thank you.
Thank you, Lordship, for sharing your insightful view on arbitration in India and institutionalization of arbitration. It was a pleasure and a great learning experience for us hearing the insightful knowledge shared by the Honorable Law Minister and Honorable Justice and the views of our esteemed panelists on the 4th Arbitration in India Conclave. I am of the firm view that the exchange of ideas that has happened today at the Conclave will reap long-term benefits in the field of arbitration. I am highly grateful to Shri Arjun Ram Meghwal Sir, Honorable Union Minister of Law and Justice, for joining us as keynote speaker and sharing his insights on arbitration environment in India and initiatives and steps taken by the Government of India and that will be taken in future to promote India as a hub for institutional arbitration. I would like to extend my sincere gratitude to Honorable Justice Manmohan Sir for sharing his views in his valedictory address on promotion of arbitration ecosystem in India and steps to be taken to make India a hub of institutional arbitration. I would like to now extend my warm gratitude to Shri Ved Prakash Sharma Sir, Co-Chairman Bar Council of India, for his opening address on arbitration in India and initiatives taken by Bar Council of India. This event would not have been successful without his support and support of India International University of Legal Education and Research Goa, which is an initiative of Bar Council of India. And I would like to thank them for joining as principal academic partner. I would now again extend my sincere thanks to the esteemed panelists who have taken time out of their busy schedules and gracing the conclave, and for sharing the insights and on the topic of autonomy and accountability in arbitration. Institutional arbitration is the way forward. I have firm belief that the healthy exchange of thoughts in the panel discussion will take a fruitful course to make India a hub of institutional arbitration. I would like to thank the moderator for this session, Dr. Shashwat Bajpai Sir, for moderating the panel discussion. I would like to extend my heartfelt gratitude to our silver partner Bombay Law Chambers for supporting the conclave. I would like to thank our supporting organizations without whose support the conclave would not have been successful. I would like to thank Chartered Institute of Arbitrators, Vienna International Arbitral Center, DMD Advocates, Shardul Amarchand Mangaldas, Lexide Rathi, TrademarkLink.com and Sandeep Logistics. I would like to thank our knowledge partners, OP Jindal Global University, WIPS, Indian Institute of Arbitration and Indian Institute of Mediation. I would like to thank our media partners and their personnel who have come here to cover the conclave, Z Business, LatestLaws.com, Haribhumi and Janta TV. I would like to extend a special gratitude to our respected board of advisors and members for their constant support and guidance, and our arbitrators who are amidst in our audience. I would like to thank Shri Manoj Sharma Sir, our IT head, and his team for working tirelessly to develop IDRC's software and software infra. I would like to thank our team members Ruchi, Jagriti, Ankit, Siddharth, Amit, Prakash and Himanshu and others for their hard work, without which this conclave would not have been successful. I would like to thank our esteemed guests and audience for joining us today for the conclave. We are highly obliged to have you with us today. I would like to thank India International Center and their staff and service providers. Thank you. With this, we conclude the 4th Arbitration in India Conclave 2025, and we look forward to see you for our next edition. I would like to request our Honorable Justice and Law Minister to join us for the high tea, and our guests and participants to join us for high tea. Thank you. Enjoy the evening.
IDRC is an initiative of International Dispute Resolution Council, a company registered with the Ministry of Corporate Affairs, Government of India, and the NITI Aayog.